advisory firm. We have expertise in data protection, startup advisory, emerging tech, health tech, and basically intellectual property as well. So that's under our startup advisory team. So this event is organized in collaboration with IP Series. So IP Series is a platform, like a podcast where they discussions about emerging trends in the IP space, trends in the industry, and IP discussions basically. So that's something that you want to check out after the event. So now I'll be handing over to our speakers to introduce themselves to the audience. So I'll start with Liz. Hi, Liz, welcome.
Hi, how are you? Hi, how is everyone? Thank you for the invitation. I'm humbled to be here and happy to be here. My name is Liz Lenjo. I'm an advocate of the High Court of Kenya, and I am also the chairperson of the Copyright Tribunal. When I am not the chairperson of the Copyright Tribunal, I run a boutique legal services firm by the name My IP Legal Studio, where we specialize in intellectual property, entertainment, media, and fashion law. I'm also a volunteer chairperson with the Technical Committee on Intellectual Property at the Kenya Bureau of Standards, which is basically the standardization body when, in terms, we are basically the listening ear, or we are like a wall where they bounce off ideas whenever they are trying to standardize new products in the Kenyan market, and when they need advice in terms of matters intellectual property. And I'm also the Creative Commons chapter lead for Kenya. So I look forward to having some amazing conversations this year on this year's World IP Day. Thank you.
Thank you, Liz, for that wonderful introduction. We're happy to have you. So I'm moving over to Shedina. Please, can you introduce yourself?
Yeah, thank you very much. My name is Shedina. Sorry, so I am on my phone because the laptop camera is not working as well. So my name is Shedina Muhammadu Njai. So I go by Shedi when am I into a Anglophone platform. So I am from Senegal, we speak French. It's easier to call me by the name of Shedi. I am a social entrepreneur, mainly working around youth development and youth empowerment and youth automation. But I do have a big background on digital technology, politics, and digital growth, where I had several cooperation with the public sector around data privacy policy, around like the strategic development plan around digital growth, and also around cyber criminality. The question of internet intellectual property is very crucial when you are a social entrepreneur, and also coming from the open source community here in Senegal, there is a different patterns and framework based on internet intellectual property that we try to design are still in progress, and also are still a big challenge here in Senegal. Thank you again for this opportunity.
All right, thank you for that introduction, Shedina. We look forward to hearing from you. Thank you and welcome to the panel. So I'm moving over to Eunice. Hi, Eunice. Please, can you introduce yourself?
Hi, absolutely. Hi, everyone. Apologies, I'm unable to turn on my video. I'm currently in San Francisco, and it's about 4 a.m. here. So, I'm excited to be on the panel. My name is Eunice. I'm CEO and co-founder at a tech startup called SideBrief. And what we essentially do is we provide a simple digital platform for entrepreneurs to launch, to manage and scale their businesses across different countries from anywhere. So we're a one-stop solution for your business registration, for banking, and for annual regulatory compliance. We also do have an intellectual property product called Shield, and which allows you protect intellectual property across different markets. I'm excited to be here. I'm excited to be a part of this panel. I look forward to sharing and also to learning from the other panelists. Thank you.
Thank you, Eunice. We look forward to hearing from you. So I'll move on to our last speaker, Peter Billet. Please, can you introduce yourself?
So much. And hi, guys. My name is Khatabile Tepe. I'm in Lesotho currently. I am a researcher, a cyberspace researcher specializing in cyber psychology, cyber mental health, and cyber disorders. I have contributed in 2 international white papers, and last year I had an issue brief on that was published on mental health and technology, a case for Africa from the Observer Research Foundation in India. And currently I have started with cyberspace awareness campaigns, and the twist in it is I'm using the arts as a tool for communication. And we have an exhibition on a cybercrime that focuses on children, which is online grooming. And in Lesotho currently, there are no reported cases because a lot of us still don't understand the different cybercrimes that exist. So hence the awareness campaigns. And I'm also looking into promoting the arts. So I'm trying to use technology and the arts and just try and make sense of everything and for people to understand cyberspace related issues. I look forward to today's discussion, and yeah, thank you.
Thank you, Peter Billet. We look forward to hearing from you. And welcome to everyone. So we're going right into conversations for today. So we're focusing on women as creators, harnessing intellectual property protection in Africa. So we're going to be hearing from our speakers from their experiences. So they're going to be speaking majorly from their experience as different industry players. So I'll be starting with Eunice. So Eunice is a co-founder of SideBrief. So we want to know, as a co-founder and a CEO, and also a woman, we want to find out from you, what role do you think intellectual property plays in the development of your ideas, your products, and basically the role of intellectual property in your business, and what has been the approaches you have adopted in past years to ensure that intellectual property is made an integral part of your business?
Right. Thank you so much for the question, and happy to, take a shot. So yeah, like you rightly mentioned, for us, intellectual property is a critical component of our business. And I would say, for most business, especially if they're tech businesses or tech-enabled businesses, where innovation and creativity are literally at the forefront of our product development, it's really a big deal for us. And as a founder, I believe, and obviously having a legal background too, I believe that protecting our intellectual property is really essential and really very important for our company's continued growth, right? One approach that we've taken is to prioritize intellectual property from the very start. So when we started out at SideBrief, it was very important for us that we knew what we wanted to trademark. We knew the intellectual property framework in the regions that we're currently operating and those that we intended to expand to. So we kind of had we're going to be protecting our trademarks and all that things, that other intellectual properties that are important to our business. And obviously, because trademarks are territorial, apart from a couple of Francophone countries that are under the same framework, we highlighted the markets we wanted to protect our intellectual property in, and we went ahead and registered those with the appropriate bodies, right? So to be honest, I think it's really important, right? We do have also a team of internal people who are constantly monitoring our trademarks in the jurisdictions they're registered for potential infringement and any of those things. But literally, it's a really important part of our business, especially as a tech company. And we've literally prioritized this and made it an integral part of our business. Yeah.
Okay, that's a very nice perspective from Eunice. Thank you for that response. So I'm handing over to Daniel to drop the next question.
Thank you so much, Dorcas. Thank you so much, Dorcas. The next question we have is for Liz. Liz is the chairperson of the Kenya Copyright Tribunal and also the founder of My Legal Studio. So, Liz, we want your perspective on this question, and I think it is an exact one. Your experience as an IP expert who has handled legal projects from jurisdictions within and outside Africa, what can you say is the benefit of IP protection for businesses in Africa? And what do you think is the reason for the low participation of women in the IP system? And how can women be encouraged to participate in the IP system and harness the benefits of their business? Like a multi-question, complex question. I don't know if you want to take it again.
Yes, I got it down. So it's a good question. It's a very pertinent question when we're talking about the growth of businesses from a local perspective to an international to a continental perspective and the participation of women. And I think, in terms of benefits, and intellectual property has been an underdog in the business space in Africa generally. And unfortunately, it's also there's a blame we have to bear as lawyers as well. We've seen where lawyers really underplay the value of intellectual property. Some of them will, categorize it as this subset of commercial law. So you find most of the time they don't pay much attention. However, when you look at even just the global trends, some of the greatest and biggest companies are what they are because of intellectual property. Yeah, they are very deliberate in how they secure their intellectual property assets, in how they interact with these assets that they create. So you find that they are very deliberate. And it's always interesting when you look at some of the trends and comments on social media. Like in Kenya, for example, you hear people make comments like, when someone is trying to assert the intellectual property, they will say things like, oh, they're so petty, they should just let them be. And, they're basically entertaining, infringement, be it copyright or trademark or, whatever infringement in IP is concerned. So I would say one of the greatest benefits is you're just securing their business. It ensures longevity. Once you have secured your intellectual property, you have secured your longevity in the business, in the space that you're in. You're securing your profits, you're securing your market, because as long as you have your IP, your consumers know that this is X by Liz. This is the brand that Liz is involved with. This is what she sells, or this is what she's predominantly known for. So, even just protecting yourself from unfair business practices, someone trying to market their product with a similar name as yours. So as long as you've registered your trademark, for example, or your trade dress, then you're able to assert that control and that property. Without that registration, then it means that, someone else will come register something similar. And in the absence of that registration, depending on which country you're from, you could easily lose it. And I think most African countries have a fast to file approach. So, just understanding what IP have I created and how I protect it is really important. And I think we really need to stop thinking about IP protection as a liability, as this expenditure that will never be recovered. I don't know where people have been getting this notion from. However, if you look at a trademark, for example, if you register it in your country, you have protection for 10 years. You paid once off for 10 years. So, and in the subsequent renewals, the fees that you will pay are much, much lower. So, things like that are really important to understand and be aware of. In terms of law protection, again, I think it's just the issue of costs, the misrepresentation. I think we're not talking enough about these benefits. We're not showing where the money is. Right now, money is the greatest force in terms of any business. How do I create wealth? How do I create a legacy? So how do we show this value of IP? And I think especially as IP lawyers, because we know why it's important, I think we need to start writing more and speaking more about such issues and showing where the money is. I think any entrepreneur always wants to know where is the money. So I think that is something we really need to do better as African lawyers. And I think we will get there. And then how do we boost participation of women? I think just the basic encouragement, speaking even as a woman, most of the time in the business space, we have this imposter syndrome. We always feel, quote unquote, like the lesser person in the room for some reason. And I think it's also advised by culture, right? So you find that, some of the things that you have learned, even from a familial or family perspective, you tend to carry them in business. So you tend to be very timid. But we're seeing women are slowly becoming more brave, more courageous, more fierce, and I think the more we fearlessly and fiercely protect our IP, we are quick to run to litigation. I think we should be more encouraged, just because we are afraid of that stigma. Oh, she talks too much, or she's always complaining, she's such a woman. I mean, sadly, it's the truth, but I think we need to start shedding that mentality and being more proactive. And, once you know and understand the law is on your side, I think you should actually, fearlessly do it like a man. We need like a man, so to speak. Thanks, Daniel.
All right, thank you so much, Liz. I think for those of us who are joining, I think there are lots of takeaways from what Liz said, particularly that we need to talk about the value of IP and show the entrepreneurs where the money is. And of course, entrepreneurs must stop seeing IP protection as a liability. It's actually an asset. Thank you so much. I think Eunice hand is up.
Yeah, my hand is up. I just wanted to chime in what Liz was saying around not seeing intellectual property as a cost, and how important it is by sharing just one scenario that I was exposed to. So I had an entrepreneur, startup founder who was just literally talking to me a couple of months ago about their intellectual property. So they were currently in the App Store, and they did have another company who was saying that they had been using their name for a bit and that had to take down their app, right? At the point, they were obviously hadn't trademarked the name, right? So they had no proof to show that, they had been doing business with the name for a while, except, the website and a couple of all those things, they did not have legal protection, right? At the point, obviously, when they were starting out, they thought it was too expensive, but obviously getting thrown out of App Store because someone had, a better legal claim to that name was obviously an expensive one of them. So circling back to Liz's point, right, it might be a bit, and I don't think it's that expensive in most African countries, to be honest, right? But it might come at cost, but it's really something that entrepreneurs really need to take very importantly, especially if they're building a business that would scale or that would grow over time. Yeah, thanks, Daniel.
Thank you so much, Eunice. Thank you for your contribution. And of course, there are lots to learn from what you just said. I think I'll hand over to Dorcas to take it up from here. Thank you so much.
Okay, thanks, Lee and Eunice, for that wonderful contribution. So that brings me to a very interesting question on protection of intellectual property. We have a creator here. Vitabile is a researcher, and I believe that she has done a lot of work in this space in terms of creating content, right? And since we're discussing intellectual property benefits and access to intellectual property, and even the importance of protecting your IP so it doesn't get stolen, or you don't even get to receive the benefits of that work that you have created. So, Vitabile, what has been your approach so far to ensuring that your work is protected? And do you think intellectual property plays a role in your career at all? And what has been the challenges so far that you've encountered in trying to get intellectual property protection for your work?
Thank you so much for that question. Okay, I think for me it's a bit different, and I look at it from quite a number of perspectives. Number one, with the think tank that I'm a researcher for, and with the 2 white papers I contributed in, it's always, we like, even in the contract that I've signed with them, is the work that we do together, the work whereby I contribute or whereby I write, the work, the published work is there, it's the foundation's property. Do you understand? So I try not to look at it from a negative point of view, because what it means is my work out, or I will always have a point of reference for my work. It's never going to die. It's never going to get deleted. I have that footprint for life because I'm associated with the think tank. And even if I wasn't, I can still reference that these 2 white papers can be found at the foundation, you know. And looking at how I worked with last year when I was asked to write an issue brief on mental health and technology, it was still the same case. It's their property, not can't use, or I can't start using the published papers for any other purpose. Sorry about that, guys. For any other purpose. And I feel like it's an advantage for me, because it means that I don't have to stress a lot about it. And 2 weeks ago, a friend of mine, a journalist friend of mine, was like, "Hey, Tabby, why don't you register? Why don't you trademark? Why don't you?" No, she was like, "Why don't you open a blog or start a blog?" And then I was like, okay, I've thought about it before, but okay, it's fine. And then she was like, just go to the law office and find out how you can protect your work. And then the following day, I went to the law office. And when I got there, I asked that, can they just tell me, I want to start a blog and I want to protect my writing. And then this is where the trademark came up. And then I was like, I don't know why I always decide. I've always decided, or I've always said that if I trademark anything, it's going to be my name. So I asked that, is it possible to can I trademark my name? Because my work, I can't separate my writing with myself, you know, it's one and the same thing. So, and that's what I'm going to do this week. I'm going to trademark for the blog that I'm going to create, so that everything that I write, no one can use. And I'm just not sure with how the trademark laws work in South Africa, because I'd also want my work to be protected that in South Africa, because I'm also a South African and I study there. So I think it's just a matter of finding out how that is going to work. But in research and academia, I think the best part of it is you will always have reference to your work. And I think it's just because I try not to look at this particular thing in a negative way, because it's reference, it's there. And I think that's a bonus for me, as well as the work I do as a researcher. Thank you.
Okay. Thank you so much for that wonderful perspective. Like, it draws more attention to the importance of intellectual property and why we should even consider protecting our intellectual property. Like she said, she is going to trademark her name, and we all know that that's a very important move, because her work is associated with her. So if she does a research, like, this work is coming from this person, and then that's heightens the importance of intellectual property in this respect. And there's no way that someone is going to reap the benefits of that. So thank you so much, Tabile, for that contribution. Okay, Liz, you want to say something?
Yes, let me say something. I think one of the greatest things about such webinars is also to help correct some of the forgive my lack of a better term, some of the bad manners that is happening in the IP space. As an entrepreneur, remember I earlier said that for some reason we always imagine or believe that seeking the services of a professional is a liability, right? The example that our speaker just gave just showed some of the dangerous terrain that we walk in terms of identifying the role of an IP office vis-a-vis a professional like an IP lawyer to assist. Now, the truth be told that most of the time our IP offices are equipped with individuals who have basic information, yeah? They have interacted with the subject matter in the IP office to the extent in which their designation extends, all right? So which means if I decided to go straight to an IP office for legal advice, I will only get it to the extent in which they have been exposed to, which then means that my business is also exposed in terms of to what extent am I well protected? So unfortunately, in this instance, they have not explained to our researcher, because I can't pronounce her name well, and I love that accent and how she pronounces her name so well. They have not explained to her the difference between a copyright and a trademark to begin with, so that then she understands that as a researcher, I have, first of all, my initial asset is the copyright in the articles that I write. So which means that she is better off going to a copyright office to confirm, or to better still, an IP lawyer who will give a wholesome approach. But it would mean that she's looking at copyright. What does it take to protect copyright in South Africa? Is registration of copyright a must? So for example, with copyright for the longest time, it's always been protected automatically the minute it moves from an idea to an expression, right? So if it's a book or an article, the minute I write it, it's automatically protected. However, we have seen eventually over time, registration has been a conversation in terms of protection. So in some countries, you will find that it's expressed in their Copyright Act that for you to be able to successfully sue for a copyright infringement case, a registration must also follow once you create your work. For example, in some other jurisdictions, all you need is just enough evidence to show that I am the creator of the work and an infringement happened. And then now the issue of trademark comes in terms of how are you branding, say, for example, your publication or your blog, being informed about some of the pitfalls of having trading in your name, for example. And the pitfalls can be very many, and they start from just how you register the business. If I'm going to register as a business name, for example, then it means that myself and the business are one and the same. In the event that I'm going to be, sued for anything, I'm going to be personally liable as the business and as myself, because it's a business name. If there are any debts, they will come after my assets because it's a business name. If it's a company, then it's a separate person from my business. So, understanding that becomes really important, because then it advances the second conversation. How am I protecting my brand? If I decided to name it Liz Lenjo, for example, and I'm in a business where eventually I may seek investors, for example, that means I have turned myself into a product. I turned myself into a product. It means, what if tomorrow I want to leave this company or joint venture and start on my own? Have we seen and have we examined the past trends where we have seen people, renowned people and figures who have traded in their names? They were pushed out of a company and they could not start from scratch because they could not use a name. They couldn't even say simply, I don't know, Digest by Liz Lenjo, because Liz Lenjo was a trademark. It was assigned and transferred in a company, and now I'm basically a shell. Yeah. So I think it's always really important to be very pragmatic and practical. Yes, it will be an ouch in the pocket in the beginning, but we're looking at the long term. Where is the money? How am I making the money? How am I securing the money? And how am I securing my legacy? So it's really important to get the right advice. And I caution those who are here and, to basically know that it's very risky to get legal advice from an IP office. Half the time when the damage is done, it's usually too late even for an IP practitioner to help you get out of that situation, right? So I think, in a nutshell, it's better, you're better off finding an intellectual property lawyer to assist you. How do you find this IP lawyer? Talk to your friends, go online, research and find out in South Africa who are some of the best IP lawyers. Can I find someone on LinkedIn that I know who's interacted with this lawyer so that they can tell me, do they understand my industry? Because even with IP lawyers, you'll find that there are those who are very patent heavy, so they're on the scientific side, and then you'll find those who are more on the artistic sector, and they're able to speak more conversantly about copyright or whatever, so that research is really important, because also when you're finding a lawyer, it's like a marriage, it's a relationship. So you don't just marry any Tom, Dick, and Harry you find on the street. You need to have done your homework. And I think we need to start embracing the process in which we also seek legal counsel and how we engage lawyers. Just like the way you will hire a CEO or a sales rep for your company, you do your homework, right? So do the same with your lawyer, so that then you're in the right hands, and they will take you to where you need to be. They will help you secure that bag.
Thank you, Liz, for that wonderful contribution. It's quite insightful. And we believe that creating awareness for creators is very important, because not all creators are aware of the intellectual property rights that are available to them, which ones to go for, and then which ones not to go for. So we're going to come back to that discussion much later. We're going to be discussing the laws that creators should look out for, and then what's your advice should be for creators who are unaware of intellectual property rights or the benefits at all. So thank you.
Okay, thank you so much, Liz. Thank you so much, Dorcas. Said, I think I have a question for you. You're a social entrepreneur, and I would love to also call you a social political actor. I think I came across one of your writings. Very, very brilliant. And I believe you engage in creation of applications that solve community problems, and you're passionate about youth development. So now I would like to ask you, what do you think are the approaches, or should I use the word best approaches, that can be taken to promote female inclusion in IP system, and how can they, what can they do to prevent IP thefts and low return on their investments? So I don't know if you heard me.
Yes, I do. Thank you very much. It's a big question. I'm not sure if I have the real answer. So what I do know when it's come to intellectual property, based also on my journey and on my background. So that's the reason why I emphasize the open source community where I belong in the beginning of my journey as a civil servant. So into like the open source framework, at that time, if you want to democratize the access of technology, you need to set up, as we just mentioned, a contextualized framework for people to take the ownership. And also, in order to inspire more people, you are not focused on being the owner of the product, but like how can we do replication of the product? So it's literally a critical and an ethical question. Am I going only to focus on my personal achievement, or where we are actually in terms of progress, should we just democratize it by setting a level of open source tools? So the open source tool is, it's a tools that everybody can use as soon as you mention the copywriting, who's the owner, and also you cannot sell it because at that time, Africa is a very poor country. And if we want to democratize the access of technology, we need to create technology for people in popular and rural areas so they can have access. So if the technology is very expensive, it is going to be difficult to have inclusion because I think like the people into like the popular and the rural area, they are having income issues. So this was one of the first patterns that we set up in order to promote creation for the better ownership and for replicability framework in order to have big democratization of access of the technology as a community-based organizing tools or as a community-based organizing activities. So this was one of the first example. The second example, because we are working into social entrepreneurship, mainly focused on social venture and development, which can be local development or big cooperation partnership. We need also to understand what kind of collaboration and where intellectual property intervene. One of the issues that we had in our work is because we do a lot of work with like foreign aids people, sometimes they think because they are the one So I am not into a for-profit segment. So because we are into a non-profit segment and you make collaboration with like big donors, they think they are the owner of the product. And so they take all the ownership of the creation part, of the operation part, and of the evaluation part, because they see you as a prestation. They give you money for you to be like the operational part of the project. But once they do the reporting of the project, they take all the credit because sometimes they did not mention there is a grassroots local organization who intervene. So that's how we set up another innovation pattern in terms of the ownership of any innovation framework that we have designed. Also, it is very important in terms of international knowledge because the other issues is I am not trying to be caricatural, but generally African contextual knowledge is not well recognized into a global context. And for us, setting up a framework in terms of intellectual property to empower and to emphasize how knowledge, it was very critical, specifically in the non-profit segment. This is where actually we have created a big federation of youth-led and youth-driven organization in order to promote how knowledge and intellectual property based on that structure. Like how we structure ourselves also is very important in terms of intellectual property because having a big federation will succeed to create a big framework of partnership where our local expertise can be emphasized through intellectual property, because everything we're going to do is going to be labeled based on the organization. And as a founder, we don't have any issue around intellectual property. Those are the two outputs that I can emphasize. And one last thing also, into a creative way coming from a technology, you always face the ethical question, whether you are into a white hat, whether you are into a red hat. And if you are into a white hat, there is always a framework coming into copywriting when it comes to intellectual property, but also there is always putting someone else's job when you use it because he decided to share it into like for the community. So those are the three main stuff to summarize it. It is like intellectual property coming from open source way, intellectual property in order to democratize and to decentralize progress and success, intellectual property in order to have your own brand and your own knowledge coming from Africa and also into an international perspective, and the ethical framework on intellectual property based on the need and also on the dissemination and the transmission. Thank you.
Thank you so much, Said, for that insightful contribution. Very, very insightful. I'll proceed to Eunice. I think your hand is up, but still, I have a question for you, and I would love to have a perspective. You shared with us a particular company that lost their product due to their failure to protect their intellectual property. Let me ask you, let's come home to Africa. Do you think intellectual property is important to Africa's economic growth? Will it stimulate Africa's economic growth? And then why?
I'm sorry, Daniel, I lost the second part of your question.
Okay. The other link of the question is why should women get involved in the IP system?
All right. Yeah, so to your question, yes, I believe that IP is crucial to Africa's economic growth, right? The protection of intellectual property provides incentive for innovation and creativity. So the fact that that your intellectual property is protected and that you're the only one who has rights and you're backed by the system, you're legally backed, right, creates opportunities for innovation, new products, services by creatives that can literally drive economic growth, right? So these also enables, these licensees to commercialize these intellectual property. Obviously, the people who are also in the business of doing that, right? So you're able to commercialize this intellectual properties and make some money of it. I think obviously that women should obviously take advantage of intellectual property protections in their various countries. If you're running a cross-border corporation or a business that has the capacity to scale, I think it's something that people need, or entrepreneurs in general, women founders, or literally even obviously the male founders, to have to start thinking about right from the word go. It's not something to postpone, because there are obviously very dire detriments if you're doing this. Like Lisa said, most economies or most jurisdictions would give priority to the first person who registers his intellectual property. And also that, I mean, even though copyright was previously protected once published, rights, different countries are now putting in legal regimes in place to be able to see that those are registered, also in Nigeria also. But I mean, circling back to your question, right, and just, I mean, recap, right, I think it plays a very crucial role, especially in terms of commercialization. And I mean, for women, I would highly encourage that, I mean, we go ahead and protect our ideas and inventions through the appropriate legal or regulatory framework. And like most of the speakers have said, having an expert do it, or having conversations with an expert around this. I mean, they're friends you can use. You can always look up intellectual property lawyers online. I'm sure there are some database here and there that has a repository of lawyers. If you're looking for a more tech-enabled solution, I mean, obviously SideBrief is an option, but I think that would be all on that question, really.
Thank you so much, Eunice. Thank you so much. Of course, definitely IP is essential to Africa's economic growth. So I think I have a follow-up question. Obviously, a founder in the tech space, and now I want to ask you, what are the challenges faced in harnessing IP, for your business, and how have you overcome these challenges?
Right. So I mean, I would say this is in Africa, and I think in a lot of the countries, I think what we have experienced, the challenges that we've experienced, are literally attributable to regulatory and compliance procedure. Apart from the cost, I think timelines are there in protecting intellectual property across several countries. And this is not just a thing with developing countries, but also a thing with much developed countries. I would give the United States as an example. It typically takes about 6 months to a year, or sometimes even more, to be able to register, I mean, your trademark or other intellectual property that you're trying to register. So it's literally regulatory procedures that has been a challenge, right? So I think if the relevant regulatory authorities could somewhat use technology in terms of upscaling their processes, a lot of these procedures for these intellectual property protection are still manual in a lot of countries in Africa. So that has led to extended timelines. And I mean, in Nigeria, for example, right, so there's the acknowledgements, all the way to the certification stage. It takes a whole lot of time for publication of, I mean, trademark journals. Sometimes take years, sometimes it takes a whole lot more to have your certificates published, or your certificates issued to you, rather. And we've seen a situation where lawyers would literally have to use their own money or pay at the registry to be able to get some of these documents or out. So mean, I would say regulatory challenges apart from cost challenges, cross-border, right? When you're a foreigner trying to register in a new African country, that can also obviously be more expensive for foreigners versus locals. I would say that unifying that, I mean, pricing in some sort of way, obviously for fellow African founders or companies would also go a long way in encouraging these founders or entrepreneurs to register their intellectual property in other countries. I would say that, I mean, Francophone Africa, as some countries, and maybe Sadina would have more perspective on this, have kind of like unified the framework. So if an intellectual property is protected or is registered in one Francophone country, there are a number of member countries that are also protected by these singular framework or registration. I think initiatives like that would also go a long way in ensuring that we don't face a lot of bureaucracies. And I mean, just having a more autonomous system, a more harmonized system, right, would ensure that we don't have, I mean, or we don't experience IP infraction, and to ensure that, I mean, that the timeline can be more predictive or predictable, and would ensure that, I mean, entrepreneurs are eager and willing to also get this done. Yeah.
Much. Thank you so much for the immense contribution. And I obviously agree with you that we need to stop our IP regulators to stop slow walking the process of IP registration. That's to encourage creators to register their IPs. Very, 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 very pivotal. Thank you so much.
Sorry, I think I missed the other part of your question was, I mean, how have we overcome?
Yeah, overcome them. Oh, I thought you actually answered them. Okay, let me allow
Yeah,
you
so
to.
I mean, it's an ongoing process, right? I mean, for us, what we've tried to do is engage with these regulators, ensure that, I mean, we're in constant communication with them, put our problems and our challenges to the forefront, and try to, I mean, work together to solve this. But I mean, I think that there's still a long way to go. I mean, I would also be interested in, I mean, getting experiences from Liz, obviously in, I think, Kenya, and I think our other speaker from South Africa, just to understand how the regulatory framework is in their country and how fast most of these processes move in these countries. Yeah.
Your perspective on that, on how you are currently overcoming these challenges. I think I actually learned from that. Thank you so much. Yeah.
Okay, so thanks, Eunice, for that perspective. It's interesting to hear from a founder, a business owner, the challenges that they face in getting intellectual property protection for their businesses. So it's good that we have an IP expert here. So I would like Liz to tell us you must have advised business owners on the relevance of intellectual property, what to do, what not to do in order to protect their work. So what laws do you think creatives should look out for and taking from UNICEF with respect to physically?
We're losing you. Daniel, did you hear her? You're muted.
I'm on mute. Can you hear me now?
Yeah, now I can hear you. At some point you were disappearing. You are on and off, on and off. Please repeat that.
Okay, I apologize for that. So I was saying, we heard from Eunice as a business owner and a founder, and she has said one of the challenges that business owners generally face in Nigeria is the regulatory framework for intellectual property protection and basically the bottlenecks that they have to go through the procedure for obtaining intellectual property protection for their business in Nigeria. So I wanted to hear from you your perspective on this. What is the regulatory framework like in Kenya? And then what do you think business owners or IP owners should look out for in terms of the laws that govern intellectual property in Kenya or in Africa generally? By looking at IP laws generally, what laws do you think we should look out for, and how is the regulatory framework like in Kenya?
Okay. So I think first and foremost, when we're looking at how the different regimes of IP operate, we sort of have a standard global approach. So for example, with trademarks, the standard procedure or period is usually about 6 months. An efficient system will grant you a trademark in 6 months, which means it's gone through the search process, and then there's feedback. Once you file a search, you get feedback from the office of the registrar through the examiner, and they tell you this name isn't available, or you may have to disclaim, or whatever the feedback you get. And then based on that, you proceed now and make an application, either based on the amendment that has been recommended or proceed as informed. And then after the application, there's the examination stage. And I think it's always prudent to remember that, there are so many other citizens or people who are also making those applications. So, just being cognizant that, even if we were to make it a machine process in terms of examination, I think there's a possibility of some errors, which means then there will be opportunities for more oppositions. This is where you find that you're either fighting a decision by the registrar because there was an error in the system. So maybe the automation of communication is what is really important, because, for example, here in Kenya, they still use the PO box, and I have an email address and I can get feedback in real time. I up to date, I don't understand how we still, have found the relevance of a PO box. So I don't know about Nigeria, but I think it's the same, because I've seen that happen with my clients' applications. And when Off Council will send me feedback, they had to go to the post office box or call the IP office for at least an advance copy. It's very interesting. That's one thing I think as African we need to reform for a fact. So, but when you look at just that process, the examination process, depending on how complex or similar the mark is, you find that two examiners will have to play tag team for them to give a balanced response, right? Then after that, now the mark will proceed to advertisement, which is 60 days. It takes 60 days to advertise a mark, waiting for an opposition. If there is no opposition, then it proceeds to registration. So you can see already that process. You need time. So, but an effective system would take 6 months. Being government, up to 9 months, that's an efficient system. 6 to 9 months is efficient. Anything after that is problematic. I think the one thing that stands in between the efficacy of this system is the automation of the responses. Most of these IP officers need to embrace technology and use our email addresses. It doesn't make sense that I put all this on record and then all you focus on is on the PO box, right? And then one person in the office, I write the letter, then I send it to Daniel, then Daniel gives it to the mailman, then, like unnecessary, right? So I think that's one thing we could definitely do better. And then hopefully eventually we'll get into a situation where we can now make these applications online. It's okay that they're going to be done manually, that's fine. But if it can be done automatically, that will lessen the burden. It will lessen, the queues at the IP office. For us in Kenya, thank goodness for M-Pesa. So immediately you go to the IP office and you lodge your application, you get your trademark application number, and that becomes the reference number of your mobile payment. Automatically you do the payment, you send the confirmation of the payment immediately, and a receipt is issued and the process begins. So, such automations have really been amazing, and hopefully other African countries will also borrow that, figure out better ways to make these payments then it's, less of a logistical nightmare, right? The issue of, in terms of focusing on what IP areas, IP is diverse. For those non-lawyers who are here, I'm sure you always hear people say, I want to patent an idea, which just shows that there is limited understanding of IP law. So, being in the space that you're in, you need to understand on the onset, IP is the general body of IP that helps identify how to protect this asset that you create, and how the process of creation, or the what you create or how you express it will be examined to identify whether you need a patent, which is more on the scientific manufacturing side. And there's the issue of novelty and newness. The issue of inventive step becomes then important, and understanding that then that threshold, it's the highest form of protection. So it means in the whole world, there is no prior art for you to get this protection, for example. So you need to be aware of what law in your country, looks or provides for patents. And, in the body of IP law, we have industrial property and copyright. So patent falls under industrial property, and it's the highest form of protection. And then we have, most African countries have utility models. Americans refer to them as petty patents, which means it's an improvement to an existing patent. Again, understanding that and understanding the parameters in which the law allows you to commercialize, because nothing prevents you from reverse engineering an already registered product or a patent, because there's always that element of disclosure. That disclosure, when you create something and you're claiming you're the first one to create it, let the whole world see and confirm that truly Liz is the creator. So understanding that is a necessary step in a patent. So which means as an inventor, I can proceed and say, I like Liz's innovation, I can improve it. Fine, the law will allow you to improve it, but the commercialization, as long as the patent is still valid, then I must seek a license from the patent holder. Otherwise, it's an infringement. Then, if you're in the design space, there's the industrial design protection that protects the aesthetics, the combination of colors and shapes, the figure that you create and whatnot. And even as you hear my explanation, you can see already you can have one product that has several protections, right? I have the patent or the utility model. Then there's a certain aspect of the design. The design is another asset to protect. And then, of course, now the branding, trademark, the name that you give the brand. We have the Trademarks Act, which normally operates separate from the Industrial Property Act. So, and in my analysis, that's how most of the African countries have crafted their laws. So in the Industrial Property Act, you will find the provision for patents, industrial designs, utility models. And then for us in Kenya, we have what we call technovations for those who invent in their workplace. How do you incentivize an employee to keep inventing? So for us, we have that. I don't know about other countries, but that's something even for you, anyone who gets into the Kenyan market and an employee ends up inventing something for you, there are certain obligations you'll have to ensure you comply with, even though under an employment arrangement, the IP created belongs to the employer. And then now we have the Copyright Act now protects the expression of ideas, artistic, literary works, musical works. For us, software, I think most countries also protect software and literary works because of the source code is literally, the combination of words, letters, numbers, shapes to create that effect. Sculpture, architecture, so there's copyright. And, IP is also broader than that, depending on also the field that you're in. There are also unsung IP assets that we hardly ever speak about. For example, geographical indications. I mean, farming, for example. Kenya is known for coffee and tea. How do the farmers in a particular region harness this reputation of the good and register a geographical indication, hoping that they have a geographical indications legislation in their country to protect that, so that now when they also market internationally, they always know, every consumer knows this is coffee from Nigeria, this is coffee from Kenya, this particular region. A good example is champagne, right? Champagne is from a particular country, a village in France called Champagne, and they have that exclusivity because there's a threshold in terms of taste, how the qualities of this product are identified with the area Yeah, we have plant breeder rights. Again, you're in agriculture, you're creating new plant varieties. That's again another area of IP that is not normally talked about agriculture and intellectual property. It's also a big space. And then we have now the developing area of traditional knowledge and cultural expressions. This is the asserting of community rights. So again, as an inventor or an innovator or an entrepreneur, when you're creating some of these products, you ask yourself, does it belong to me or is it new? And how do I ensure then I get the necessary permissions first before I start commercializing and protect myself from any, legal liability? Am I going to be sued by a certain community because I took their communal property and commercialized it and passed it off as myself, or I distorted the integrity of this asset because maybe it has a certain sacred meaning or, something towards that as well, because, TK and TC is also very heavy on moral rights. So you can see the IP conversation can be really robust. So, and that's why it takes me back to the fact that an IP professional is always important, so that then you find someone who understands your space and has a basic understanding of your business to protect you from the beginning. When you get it right from a base level, then it means that you have a stronger, IP, you have stronger IP assets, you have a stronger strategy, and the longevity in your business is unshakable. It means your ability to expand. You can expand with confidence, yeah, because you have all these structures in place. When you don't have these structures in place, then you will find half the time you're also very skeptical in terms of your next move. You're like, am I sure? Should I? Am I protected? What will happen to me? Sort of thing. So but in a nutshell, those would be the IP laws that one needs to be aware of when they are starting a business and developing products.
Thank you so much, Liz. That was very insightful. I believe that every creator here has learned so much from that walkthrough. Thank you. For want of time, I was going to ask you to briefly tell us about your experience as the chairperson of the Copyright Tribunal in Kenya, briefly, because we're a bit behind time. So want to find out if there are specific disputes relating to women that you have encountered, IP disputes that have come to you in your practice.
I think, the nature of disputes that we have experienced or see, not just at the tribunal, we're yet to have disputes. So the tribunal is fairly young in terms of operationalization. We only just got, constituted a few months ago, and we're going through the process of developing regulations. And also, again, our mandate for the Copyright Tribunal at the moment is a little restricted, has a lot to do with dispute resolution between collective management organizations and the regulator, Kenya Copyright Board. It has some flexibility in terms of, granting remuneration where, musical works, unfortunately, only musical works where it's been used in a broadcast without authorization. So there's some things we're trying to clean up shop and hopefully, get better legislation for that. But I think we are very lucky to already have a tribunal that is dedicated to copyright matters. So at the moment, all we're telling our, Kenyans is that, the easiest way to get access to the tribunal and the faster timelines is to submit a contract or a copyright dispute in a contract to the tribunal. Then it's much easier because the parties are willing to, come before the Copyright Tribunal. Then it's much easier as we wait for the legislative development. So for those lawyers who are here, if you end up representing a client who's, asserting some rights here in Kenya or starting a business here in Kenya, in your dispute resolution clause, matters copyright, you can submit them to the Copyright Tribunal. Within 60 days or so, you have a ruling or a judgment, depending on the situation. So I think that's really amazing about that. But now when it comes to disputes, I can't really say that the disputes are have anything to do, because they're just general disputes that any of us would be subjected to. But I would mention this in terms of trends. When we see how women prosecute their intellectual property, they're always very timid. One, Two, they do the bare minimal in terms of research, in terms of even giving themselves a pep talk to see that they have a claim, they have a right. So you find that, as lawyers, sometimes we end up being psychologists. We end up counseling our clients, and we're like, even end up drawing a chart, and you're like, please, let's go to court. By the time a lawyer is telling you, please, let's go to court, they can see what's happening and what you stand to gain. So I think, earlier, back to my point in terms of women need to be more fierce. It's based on observation, because the male clients I have, they have that can-do attitude. I will do whatever to secure. Even when you tell them there is jurisprudence that is against you, they say, no, I think I have something new. Just challenge it. Let's see what comes of it. So they're not even afraid to learn. That's the other thing. So they always also have, they're open-minded. They're like, I may lose, that's fine. I may win, yay for me sort of approach, which I really admire. So I think it's really important that as women entrepreneurs, we study more about business trends, about IP trends, so that then we come with an open mind and the willingness to fight, because there's so many laws that are usually there that are working for some of these entrepreneurs, but there's that fear that we really wonder what it's about. Maybe sociologists will study more and tell us. Maybe they need to speak to more IP lawyers, and we see if we can come up with a way forward. But all in all, I think we're doing better. A lot of women are innovating, and especially for us in Kenya, we have so many brands in the beauty and fashion industry that are predominantly women. If you did a census, I think 80% of the products are from women, and the economy for locally produced fashion and beauty brands here has really grown. But now the issue of IP protection has been a problem, and they're also now moving towards other jurisdictions. So that conversation around fierce protection of IP becomes really, really important, and having that strategy in mind.
Yeah. Thank you, Liz. Thank you for that interesting submission. So basically, women need to be more fierce and study more on their various industries to know the trends, and then what to do and what not to do in the space to get protection for their businesses. Thank you so much.
Thank you so much, Dorcas. Thank you so much, Liz. Lots to take away from your contribution. So Ritabile, I would over to you. I can see that your hand is up, but I have like a twin question for you. So maybe you can take them all together, your observation and then your perspective as well. Eunice has actually told us about the obstacles, the bottlenecks that creators face from IP regulators. Liz has also explained to us relevant laws that we need to take into cognizance as creators. And she has also explained, told us the challenges she has seen as a chairperson of the Copyright Tribunal in Kenya. So let me ask you, as a researcher, what advice do you have in harnessing IP protection for their creation? That's the first part of the question. And the second part is, in your opinion, do you think IP protection contributes to innovation and creativity in Africa? So I think you can answer the questions, although I just want to point out that we are actually running a schedule, and I will be very grateful if your response and reaction can be actually brief. Thank you so much. Ritabile, I don't know if you got me.
Oh, okay. No, thank you so much for that question. Okay, an advice that I have would be for anyone that wants to get into research work or into academia as a whole is to understand the laws that come with it, because like I've mentioned with my presentation is when you get asked to write, for example, research papers, there's a contract that you sign. You don't just write and submit. There's always there's processes, steps that you go through. And whenever you feel like perhaps you're being used or you're being exploited, then you can decide that, you know what, I don't think I can carry on working with you or collaborating with you. And this is what I realized last year when I was busy with the issue brief, because I was given a topic and we had to discuss it. Okay, so this is the perspective that I'll present. And then later on in our agreement, I realized how important it is for communication as well, from both parties to understand what are the expectations. And for me, because I'm still new in this, I'm allowing myself to learn as much as I can. And this is why I say, for anyone that gets into research work, just tie yourself or connect yourself to a foundation or an organization that you feel you share same values, or you share different topics, you understand. So I think that's the first step that anyone can take in research work. Thank you.
You're muted, Daniel.
I'm muted. Still with Isabella, very briefly, due to lack of time. You answered just a limp of the question. The other part is, do you think IP protection contributes to innovation and creativity in Africa? Just briefly, in less than a minute.
Sorry for that. Absolutely, it does. It contributes. And I feel like with all the speakers and with what Liz said, that we just need to understand the different types of intellectual property and know which one is best and suits in this campaigns, because we are getting into a digital age, and protecting your work digitally online means that that's employment for you, that's employment for everyone, because this is now the part where you entertain or you propose earnings. So we need more awareness, and I think the challenge comes when we focus a lot on the negativity and we focus a lot on the negativity part of IP, because we don't have a lot of awareness campaigns in this conversation, so we really don't understand much. So we tend to conclude on just a few understanding we may be exposed to. Thank you.
Okay. Thank you for the insights. So we're wrapping up. We have a question in the chat box. So I'm going to read out the question and any of the conversations have addressed the question in parts, but then I'm going to read out the question. So this person is asking for the challenges that needs to be considered when applying for trademark protection within the continent, and how subjective are the trademark examiners? What is the likelihood of the trademark actually being registered?
Let me take that question. So, I think the first thing any IP lawyer would need to do when a lawyer walks into a room and say, hi, I want to register trademark in Ghana or Tanzania or whatever, even just a preliminary search on the digital space will help you first even identify the possibility of that registration, so that you're able to tell them, you know what, when I look on the internet, a basic search tells me there's brand X already registered. So you may need to go back to, you may need to re-strategize and rebrand, for example, because of that whole likelihood of confusion. Chances of registration are going to be slim, for example. And then if it's a foreign word or a local language word or whatever, identifying what is the meaning, right? Does it have any derogatory meanings or whatever, or the likelihood of being misconstrued? And if that misinterpretation is likely to happen on the registration side, which means then that registration is likely to be refused, all those things you deal with from the beginning. Because once an application appears on an examiner's table, that's one of the things that they will be looking at, that trademarkability. Is it distinctive? Is it non-descriptive? If it's a foreign word, what does it mean? In some countries, you will find that even if it's a foreign word, but it's descriptive, they may refuse it, if it's a word that you think you have creatively used it, you sort of twisted it, but there's a descriptive element, for example, then you might find yourself being refused. So for example, in Tanzania, the Swahili language can be very interesting. I could use one word in a different way and you think it has a different meaning, but it's about music, for example. So you find that they could refuse it. I'll give an example. We were part of assisting to register Mdundo. For those who are music users, we tried to register Mdundo in Kenya and Tanzania for the class of entertainment. Now, Mdundo is a Swahili word that can be coined in different ways. Mdundo, in its strict sense, means a rhythm. Yeah. So you would imagine for even a trademark lawyer, I'd be like, yeah, I think it can be registered, right? But on a linguistic perspective, it was found to be descriptive because it describes music. Yeah. So particularly for that class, it failed because we're talking about music, we're talking about entertainment, and we were subsequently told we couldn't even disclaim. Yeah. So you find that, the use of devices that are common in a particular industry may also be refused. So if you're going to use a microphone, for example, under class 41, which is entertainment, which is music, maybe it's a music company, the chances for you getting that trademark over the microphone are almost nil, right? Because of that descriptive element as well. So you'll find that those are the kind of, that is the kind of examination that goes into granting a trademark. So that's why it's always important that as an IP lawyer, you have done your preliminary research and perhaps, save your client that heartache of paying statutory fees only to be told, I'm sorry, no can do sort of situation. Yeah. So that's what I would say. But you find that those examinations are pretty thorough and pretty standard. You'll find them very standard in all these jurisdictions. If you're going to do OAPI, they have a unified voice. We are seeing also in East Africa, our offices have a uniform way of doing things. We also see West Africa have a uniform way of doing things. If I register trademark in Ghana, then it will be accepted in Nigeria. If it fails in Nigeria for reason X and it's probably common to Ghana, you will find they will speak the same language. So that preliminary research is always important for any IP lawyer.
Thank you, Liz. You've provided a lot of information there. I believe that anyone that dropped that question is satisfied with the response. Really appreciate you. So we're wrapping up. We appreciate all our speakers. So we're going to be taking final words from each of our speakers. I'll let Liz catch her breath. So I'll come back to you. We'll wrap up with the final words later. So I'll start with Shedina. Final words. So our topic has been, our conversations has been around encouraging women to participate in the IP system and how to get the benefits of intellectual property for their businesses. So I want to hear from you just briefly, what advice do you have for female creators in terms of harnessing the benefits of intellectual property for their various businesses?
Yes, thank you very much for this, for the question and also for the talk. What I do observe based on other people narrative, those other speaker narratives, and also it's the issues generally that we face when you are a creator or sometimes when you are a founder, is we don't have a clear view of what we need as a business owner, and sometimes we forget the legal structure of the business, and generally that's why we are not focusing into like the IP, intellectual property. I'm sorry, I always thinking about IP when internet property, so that's why I'm having issues. But yeah, as in terms of intellectual property, I think one of the big advice as a creator, as a business owner, is to have legal advisory. from our organization and our federation. In the beginning, as a designer, as business development people, and as executive, we was mainly focused on how to make the business grow until we start facing intellectual property and legal framework issues. And this is where we just start questioning, there is something missing into the shareholder framework that we designed, which was like the lawyer framework. And from there, for any activities or any product that we're supposed to design, before we even start implementing the design, we just need to have legal advisory from lawyer. And generally, I think in Africa and in the ecosystem, it's something that people are missing, I think, because it's due to the lack of money. I think also it's sometimes due to the lack of management skills in order to identify the different share and stakeholder that we need to make our business being sustained. And also, I think it's due to the networking that we made, because generally we make networking or business development stakeholder mapping based on the funds and the grants and also on the customer's journey that we want. And we always forget the legal framework. And the last point is also like the public sector. The public sector normally has supposed to set up a framework and structure for people to solve those issues. And I think like Liz talk about it. Sometimes the fact there is no automation. It's an issue. I think also corruption issues is an issue. I think also the fact that it's going to take so many times just to get your paper to be there is another issue. And to have a legal business is going to help to solve all these issues. If you don't have legal business and you want to have intellectual property, people, they can take advantage of you because you don't have any legal framework just to face like the issues that you may have if someone is stolen your issues. That's why my last part of advice is education, mainly education on how do we manage as an executive your product to be more aware of this question. You don't have all the answer because we don't have all the expertise. And I think like making a stakeholder mapping can help you have all the answer by having all the people that you might need as an advisor into those questions. Thank you.
Thank you, Shedina, for that advice. So we're looking at creators becoming more aware of the importance of intellectual property and then seeking legal advice or legal advisory from the onset. Thank you for that advice. So I'll move over to Eunice. What advice do you have for creators? How do you think creators can get involved in the IP system?
I would say that, get involved early, keep priority, engage, to people, speak to experts in the field, to regulators. Do not try to figure this out in silo, or it can be, a little bit complex. And that is where experts come in. So, I'll be keeping it brief. And I would say for women, right, we should harness the potentials intellectual property has. If we do have, a patentable invention, a registrable trademark, for any of the other intellectual properties that could be afforded protection by law, we should go ahead and ensure that these properties are adequately protected. Thank you.
Thank you, Eunice. I appreciate your advice. So we're looking at the importance of expert consultation for business owners and why they should get intellectual property protection. So thank you for that advice. We'll move over to Metabile. What advice do you have for creators such as yourself?
Okay, I think I think that's the most important part, getting legal advice, because I remember I haven't done anything yet with trademarking because I went to the law office just to do some research. But the one thing the gentleman who was helping me talked about was I would have to apply suppose it's a trademark, I would have to apply it through my lawyer. So I was like, okay. And I remember immediately after that, I just send a text to my husband saying, okay, so this is what I've heard. So I think I should meet with our lawyer, because we do have a lawyer. So legal advice is really, really important. And like Eunice just said, don't figure everything out on yourself. And understand the difference between the alternatives or the IP or the types of IPs that you would want to get into. I think that's the most important part, understanding each one of it, understanding what trademark is, what copyright is, what patent is, all of it, so that we can make a well-informed decision. Thank you.
Thank you, Tabine, for stressing the importance of legal advice again. I think that is well noted. Over to you, Liz. What advice do you have for creating?
So I have, I'd advise the following. First, I'd advise that investors and, people with interest to invest in women-led enterprises and, organizations, because, some of the most remarkable innovations and inventions in the world have been led by women. So I think we have good grounds to believe in more women-led enterprises and entrepreneurship ventures. So let's support them, let's invest in them. For the women entrepreneurs, I would say, take advantage of some of the affirmative action mechanisms, either legislative or social, in terms of, investing in your business. For example, in Kenya, we have a women's fund where you can access funding for your business. We have an entrepreneurship fund that also deals with the youth. So you can imagine being you're a youth, you're a woman, you could be differently abled as well. So you tick all those boxes, take advantage of such opportunities because that access grants assist you to take your business to the next level. And again, prioritize legal. Some of these funding opportunities, when they look through some of the documentation, you will find that legal is the least touched topic or item of expenditure. People are ready to spend money on marketing, but what are you marketing if you've not secured your intellectual property? What are you marketing? You're basically that investment is likely to go down the drain. So have intellectual property as one of your expenditure items in terms of legal advice and registration of that. And then I would highly recommend that we invest in ourselves, go for these trainings, attend such webinars and learn more, learn something new. When we're talking about IP training, when you attend some of these webinars, nobody is trying to turn you into an expert, but the aim of such webinars is to give you at least enough preliminary information for even you to know as an entrepreneur when you're being misled even by a professional. Unfortunately, the truth is that even professionals can mislead you. So you can imagine you going into a room blind, and then you're being led by a blind person. You're destined for doom. So you come for these trainings to understand the preliminaries so that you are able to say, yo, Liz, you're lying. Liz, you're not telling me the truth. I know about why 1, 2, 3, and I thought you would say 1, 2, 3 because I have interacted with such material. So investing in yourself doesn't mean that we are going to turn you into an IP lawyer, but we are literally giving you enough information for you to be able to, assist yourself. Just the same way the doctors are always forthcoming with, telling you the symptoms of malaria, for example, or the symptoms of cholera. They're not telling you so that you treat yourself, but I need to go to a doctor. So the same thing is the same case with these legal webinars. Thank you so much for the invitation. It was awesome. It was lovely. I hope we do it again. We need to have more conversations, maybe even have an IP series and talk about some of these different IP regimes. There's so much happening in the continent. There's the AFCFTA conversation that's happening. And I think we need to have more Africans as well, African businesses being part of the conversation. Let's not just let it be to government. We're the ones who are on the ground doing business. You're the one who is trying to expand to Ghana, to Tanzania, to Rwanda. You are, as an entrepreneur, should be the right person to be consulted so that we find out what are these African solutions we are seeking. What do they look like? So I think we hope to have more conversations. We'll keep having them. And for those who are here, let this not be your first webinar. Come to many, many more that will be organized. So thank you very much, the organizers.
Thank you, Liz. I appreciate your contribution. Like, we've learned so much. Thank you. I'll be handing over to Rita. Hi, Rita.
Hi, good afternoon, everyone. Good morning and good day, everyone. I'd like to say a big thank you, first of all, to our speakers for sharing their insights and knowledge. To our moderators, thank you for doing a fantastic job. To our participants, thank you also for joining the conversations. Just like Liz says, we will definitely have more of this conversation, not just for World IP Day, but for other IP-related conversations going forward. We're also looking forward to collaborating with everyone who has attended today's event. And to wrap up, I'll say happy World Intellectual Property Day, even though the theme for this year is Women and IP, but it's a yearly event that highlights certain sectors. But thank you once again, and to have a fantastic day, everyone.
Thank you, everyone. Thank you to our speakers and attendees. We really appreciate your time. Thank you.